Hi, I'm Cal Barron and welcome to our WK Goodman's Legal Thinking podcast. Let me set you a little bit of a scenario. You're a solicitor at a UK injury firm. You get a call from a client in the middle of the night. They've been in holiday on France and they've got into a horrible skiing accident. How do you go about that process? How do you claim? Do you claim in France? Do you claim in England? What's the deal? Let's answer that today. Joining me for today's podcast is Mark Walters, a senior associate in the personal injury team at RWK Goodman, and Maud Lepez, a partner in the personal injury team who's dual qualified in France. Thank you both for coming.
Thank you.
Good morning.
Maud, I would like to start with you if that's okay. Obviously, in that introductory scenario, we talked about France. As a dual qualified solicitor between both England and France, just generally, what are some of the differences that you see between the two systems when it comes to personal injury?
Well, there are essential differences in terms of liability, for instance. So if you're talking about a road traffic accident, usually liability is much easier to establish in French law than English law, because for lots of victims, you don't have to prove negligence.
And in regards to not proving negligence, that's obviously quite a significant difference. So in terms of road traffic accidents, how does that impact cases that you hear in France compared to over in England, for instance?
Well, let's take the example of a pedestrian hit by a car. In France, the pedestrian will get compensation for their injuries, whatever happened. They don't need to prove that the driver was negligent. So, for instance, if the pedestrian crossed the road without looking, they will get compensation. Whereas in England, it's much more difficult because you have to establish that the driver did something negligent, like driving too fast.
And so in regards to that, when it comes to how we pull together claims, obviously, if you get a call from a client that is overseas, when it comes to, let's pick a road traffic incident, for example, as there's that reduction of negligence of liability there, is that kind of go into your recommendations of where you'd like to put those claims forward in regards to, do you do it in England or do you do it in France? How does that process work?
So the liability question is not what determines where you bring the claim. Where you bring the claim is the question of jurisdiction. So if you have the choice of bringing the claim in England or in France, the same law will apply. If the accident happened in France, French law will apply usually. That's the principle. But the choice of jurisdiction, which means the choice of where you bring the claim, depends on complex rules as well that we need to risk assess at the outset of the case.
I think just chipping in, it's really important that people understand and establish the two issues very early on, and that's a common mistake that perhaps specialists don't quite understand the distinction between what is the applicable law, and then the second question is what is the jurisdiction and where can you bring the claim. So those are two issues that are really important to address very early on in the case.
So how do you go about unpacking that? If I'm a tourist, for example, and I'm overseas and I get into a road traffic accident and I go to you for advice, how would you go about unpicking both the jurisdiction and the other part of that package?
So a lot of it comes down to, as Maud said, risk assessing the case. So asking a lot of questions, trying to establish a lot of the factual information. So where did the accident happen? Who was responsible? Were they insured? For example, if it's a road traffic accident, you need to find out other information such as did that accident happen as part of an activity, as part of, for example, a package holiday or something like that? Or if it's an accident against a hotel directly, was that holiday booked as part of a package, or was it booked directly with that holiday, that hotel provider or that holiday home, for example? So all these different factual issues that we need to establish very early on. And obviously the key also information is trying to establish when the accident took place, because it's very important early on to try and determine what the applicable law is, and therefore what the applicable limitation period is for bringing any claim.
Interesting. Just a really interesting point you made there about kind of package holidays. How does that impact those kind of decisions if I go and book a package holiday by a provider in the UK to an overseas country? How does that kind of impact that decision-making time when an injury claim does arise?
package holidays have their own sort of protections, so it's quite important early on to establish if that is an actual package, and that not necessarily might not be marketed to you as a package. Sometimes it could be sort of various linked travel arrangements, for example, that could constitute a package. So you have to try and establish that, even if it's not sold to you directly as a package. The other key question is then establishing who the tour operator is. So what we mean by that is who's the sort of the overall party responsible. And if the tour operator is based in this country and this domiciled in England and Wales, then we may be able to pursue the claim directly against them. So that's an important point, again, to establish very early on and try to find out, who the responsible party is effectively.
And I imagine, tying into that further, obviously focusing around who that responsible party is in that instance. If you're traveling for work, does that make it quite a different set of questions again, or are you looking at the same kind of where is that kind of original operator based?
Yeah, again, it's a different set of questions, but again, you've got to determine, is that person traveling for work? So are they on a business trip, for example, who their employer is, and whether there's any culpability that might be attached to their employer. So, for example, if they were traveling in an area where there's specific risks attached to that, have they done a proper risk assessment for that travel? So determining all those different factors, really. The other thing to be aware of course, is if you're based in England, is your contract with your employer an English contract, or is it based in another country or another jurisdiction? So there can be contractual issues as well as the issues in tort, which are those which determine the applicable law.
Maud, I'd like to turn to you just on that last point. In regards to assessing claims and bringing claims across two different countries, what are some of the challenges that it comes to balancing between the various nations and their legal systems?
When assessing a case at the outset, when a client comes to us, we will look first at whether they do have a choice of jurisdiction, of whether to bring the claim in England or in France or in another country, for instance, because there's not always a choice. And when there is a choice, then we will look at strategic and practical considerations, such as how to bring the evidence, like expert evidence or witness statements, because there are crucial differences between one country and another.
So I guess touching on that kind of expert evidence, for instance, what would be some of the, I guess, practical considerations that you look at when a claim comes in?
Well, for instance, if I have a British client who needs to bring their claim in France, usually it means that they will have to travel to France to be seen by a medical expert. Or sometimes, in some cases, we manage to get French experts coming to England to see our clients, which is more practical for them. But there are also considerations, for instance, of language. So we try to work with experts who speak English to deal with our English clients.
I imagine it's a really interesting question as well, that language barrier in regards to injuries that occur in countries where English is not the main language. Are there any additional complexities in that kind of field when it comes to having to navigate the language barrier in regards to injury claims?
Well, it means that in these cases, we incur lots of translation costs because there are always documents in one language that need to be translated in the other language. And another consideration is, for instance, if the client has to appear in court to give oral evidence, then it's much easier for them to do it in their own language. So that's why for British clients, we try, if possible, to go to English courts. But when it's not possible, they might have to give evidence in another country with an interpreter.
And I imagine clients don't find that the most daunting of prospects. It's challenging for them at times.
But this is one of the factors that we put forward to English courts when there is a challenge on jurisdiction, for instance. If we try to bring the claim in England and Wales and the defendant dispute jurisdiction, then we're trying to convince the English court to accept jurisdiction. And one of the points we are going to put forward is that the language factor is much more convenient to the claimant and sometimes to the defendant.
And obviously, we're also dealing with individuals who sustained injuries. So often, it's making sure that they're comfortable, making sure that the court's aware that there's a practical reason often. Maybe it's a disability or maybe it's some factor arising out of their injury, which means that it's not practical for them to travel or it's not practical for them to give evidence in another country. So that is a factor that we also put forward.
I imagine for the clients who obviously come with these claims, it is quite a challenging situation that they're in at times, where they're in an overseas country, they're on holiday, and they've suffered a potentially quite serious injury at times. How, as solicitors, do you guys try and navigate that to put them at ease, essentially?
I think it's a really good question because it can be really difficult. You're generally going away on holiday is usually something you've been looking forward to. Sometimes it's often a special occasion, so people will be traveling for anniversaries or birthdays or weddings, honeymoons, all sorts of things. So it's really important that we act with the appropriate sensitivity and try to put them at ease. But just establishing very early on an important relationship and making sure that they're comfortable with the solicitor and that they have a good understanding of what we're there to do and why we're asking these questions, why we're sort of drilling down into the detail and what the importance of that is. But also making sure that they're comfortable with the funding arrangements, making sure that they're aware of the practical considerations that there might be to bringing a claim. And I think we're always really honest and upfront about the process and making sure that people understand, what it involves and sort of why we should start things early, really, because they can take some time to establish the facts, particularly when, there are the complexities of other jurisdictions and gathering evidence from abroad.
On that evidence point, how does that process take shape? If, again, talking about a road traffic incident, for example, I'm imagining that we're going to have to get police reports and all that. In terms of liaising with foreign bodies, foreign authorities, is that process one that is, as you said, is better to get started quicker, or how does that shape out in terms of building a case of evidence?
Yeah, absolutely. The best thing you can do is start the process early, really, because we can help people through that process. Often individuals now with their smartphones will capture things like video photographs of the incident, of the location. So we gather all of that evidence. We also then try to speak to witnesses if there's any witnesses, particularly if they're able to speak the same language, or we try to establish, with an agent based in that country, how we can gather with the information or how we can liaise with different parties. There's often, if someone's very seriously injured, then they're often involved through the consulate abroad. So then they'll have contacts and information that we can gather as well. So it's a very similar process to as it would be here, but it's obviously slightly more complicated by those sort of language difficulties and cultural difficulties. And that's where having an expert and having that understanding of those sensitivities is really important.
Absolutely. I guess when you're looking for a kind of international injury solicitor, that's something that you really want to be tapping into, someone who understands those complexities and knows how to not work around those challenges, but address them head on.
I think so. And I think the difficulty is in this area in particular is having a vast network of people that you know and trust who are based in different countries. And that's something that over time, myself and Maud have built up that network. And we have very good barristers in this country, but we also have specialist foreign agents and lawyers in other countries, so across Europe and internationally, who can then help us in scenarios where we need to gather evidence or where we need expert advice in that jurisdiction, for example, on a discrete issue, for example, or different points that might arise as the case progresses.
So if I'm someone on holiday and for instance, it's a non-package holiday, let's make a kind of specific example, and I myself get into a quite significant injury in an accident, what should I be doing after getting that injury, essentially? What should I be doing to make sure that claim's dealt with?
Well, I've had some clients recently contacting me when they were still in the French Alps because their daughter had a ski accident. She was in hospital. It was 2 days after she had been injured. And the mother contacted me and said, what shall I do? I'm completely lost. Do I need to speak with witnesses? What do I do with the ski school, etc.? So I provided some guidance to her. I recommended that she try to speak with the ski instructor and get a report of the accident. Then she said she could speak with witnesses, but she didn't know what questions to ask. So I put together a list of questions that she could ask, questions that I knew would be helpful then in time to produce a witness statement. And she was very stressed because her daughter was in hospital when, the language barrier in hospital is very challenging as well. When people are in a vulnerable position because they need to have surgery, it's much more stressful in a foreign country. So, being able to assist clients at just when they've had the accident is helpful, but obviously our role is more in the longer term to bring the claim and put the evidence together. It's not just within the few days after the accident.
Absolutely. I imagine it's something that's not immediate after the fact. It takes a long process to get through. If you're looking at one of those injuries that you suffer overseas, how long does that case from start to finish normally take? Is there a set time, or is it very case specific?
Yeah, it's very case specific. Every case is very different, and depending on the circumstances, you've got different countries, you've got different applicable laws, you have potentially a choice of or an issue around jurisdiction as to whether you can bring the claim. So there's lots of factors that can determine the length of a claim. But we will always try to make sure that we advocate for early interim payments where that's appropriate, because we know how important that sort of early funding can be for rehabilitation and for making sure that any immediate expenses are taken care of, for example. So we do try and advocate for that as quickly as we can. The other thing to sort of bear in mind in terms of a case length is once we've established all of the evidence and we understand what the practical considerations are, is making sure that we build the strongest case possible. So that might mean getting hold of some expert evidence, getting hold of some medical evidence. So we're trying to make sure we build a strong case as well from the get-go.
And in terms of that, I guess continuing aftercare, obviously you mentioned interim payments is a great way of kind of getting that as a step to making sure that the client feels a lot better over time. How standard is that kind of procedure? How difficult is that for a client to kind of get that as a first step, essentially? Again,
I think it can depend on sort of the nature of the accident. Perhaps certain insurers are more accustomed to it than others. So if they're large multinational insurers, in road traffic cases, for example, it might be slightly easier than perhaps if you're trying to pursue an individual hotel or something like that. So it can depend on the circumstances. Where it's an employee, for example, then the employer can often see the benefit. So they would perhaps be more willing to fund that even on what we call a without prejudice basis. So that means without any admissions, it's just to engage in the rehab process. And that can be really beneficial because it just means that you park the liability issues for a moment whilst you focus on the rehab and making sure people can engage in that process and to hopefully be supported to get better quicker. And with an employer, it's the benefit that hopefully they will return to work sooner effectively.
It's an interesting point you raise around work. Just touching on that quickly, in terms of that case, is that make it a more of a minefield to navigate if it's an employee? Hopefully not fearing of any employer reaction or anything like that. Is there a case if they try to pursue their employer directly? Any additional, I guess, kind of additional complexities that probably may form as a result of that relationship changing slightly?
I think there can be in practical consequences, trying to get witness evidence from people perhaps might be slightly more difficult. But I think it's important to realise that it's often not the employer directly that you're dealing with. It goes to an insurance company of that employer. So they will have insurance for that purpose, basically. And it's the insurance company that we generally are dealing with, or their solicitors. So it's important that people understand that there is a process in place. They can be supported through that. And often, we've had cases where their employer actually encouraged them to pursue a claim because they say, that shouldn't have happened, or we accept that we were at fault, for example. So they want to help people. So it really depends on the circumstances. But I don't think it should be something that puts people off.
Fantastic. Maud, I'd just like to turn back to you. In regards to someone who requires an international injury claim, in your opinion, what's probably the most important thing they should be doing right out of the gate?
Well, I think a person in that situation should be looking for a specialist solicitor or firm of solicitors, because an international injury claim will bring challenges which are not present in a domestic injury claim. We've touched upon jurisdiction, applicable law, expert evidence, etc. An international claim will definitely bring a layer of complexity, whether it's legal challenges or also practical considerations. So having a firm specializing in that area is, I think, crucial, because you will have the knowledge and you will have the network and the experience of the type of issues that are present in these cases.
Absolutely. I imagine having that network alone is something that makes it a lot easier to pursue international claims over, someone who mainly deals with domestic cases, just because it helps kind of facilitate a lot of that groundwork, that foundational information gathering.
Yes, I think it's very important to have the network and also to have some knowledge of the law of foreign countries. Even if it's basic knowledge, but just to ask the right questions. For instance, if we deal with an accident in Spain, then we are aware that the limitation period in Spain is 1 year. If you're not aware of that, then you might miss it. And we are also aware of questions that we need to ask our local agents if we work, for instance, with a Spanish lawyer or a Greek lawyer or a Portuguese lawyer. We will be more aware than a purely domestic injury solicitor of the potential issue that will arise, so we can ask the right questions at the outset and seek the right advice from local agents.
There's also a common point that it might not be possible to bring the claim in this jurisdiction. It might be the case that we've done all of that evidence gathering, we've understood all the factual issues, and the appropriate place to bring a claim is overseas. And in those scenarios, we can work with those agents to help the client in this country, but to bring the claim overseas. So it's making sure that they have that, right of action, basically, and where that arises. And if it isn't in this jurisdiction, then obviously we can help them and support them through that process.
Absolutely. Just again, tapping back on that jurisdiction channel, obviously, the last few years, last decade has been predominantly dominated by Brexit, for lack of a better term, and the kind of reshaping of our international dealings with the European Union mostly. How has Brexit impacted bringing these claims, if at all?
It has a lot. Well, before Brexit, basically the situation was much simpler and much more in favor of victims. So essentially, a British victim who was injured in a country in the EU, European Union, when they were back from holiday, they were entitled to bring the claim in their home country. And they actually had a choice of bringing the claim either in the country of their domicile or in the country where the accident happened, or the country of the defendant's domicile if it was different. But basically the choice was the claimants, the victims, and there was no opportunity for a defendant to dispute jurisdiction and to say, oh, you can't bring your claim in England, you have to go to the other country. Brexit has changed that. So as we said early on, if you have a package travel claim or an employment liability claim or a consumer contract claim, usually you can still bring it in England. But when we're outside of these regimes, if you have a road traffic accident or a ski accident or a fall, a slip and trip accident, which is not within that regime, it is much more difficult to bring the claim in England nowadays, but it is still possible in some circumstances. So we always look at that when we do the initial risk assessment of the case, because we know that it is our client's preference to bring the claim in England if possible, because of language consideration, etc. And the system is easier to understand for them.
imagine that's had quite a practical knock-on effect in terms of, again, that case length and time. If defendants can now challenge the jurisdiction a lot more, previously it was the claimant's choice. How does that factor into, I guess, the length of claims? Obviously, you're mentioning Spain has that kind of year limitation limit to kind of flag something up. How does that make it more? Does it make it more challenging for claims in certain countries?
Well, the limitation period, the question of the limitation period hasn't really changed because it's related to applicable law and not jurisdiction. So you could, for instance, bring a claim in England, but the claim is subject to Spanish law. And in that circumstance, then the Spanish limitation applies. What has changed in terms of the length of the case, the potential length, is that when we take on a claim that we bring in England and Wales nowadays, we know that there are often risk of a jurisdiction challenge being brought by the defendant. And if they do bring the challenge, then we are looking at an extra year approximately for the jurisdiction challenge to be decided by the court. So it's longer and there is an added risk for the client. So we need to explain that to them at the outset.
Yeah, I imagine the client being told an extra year wait might not make them the happiest person at times.
No.
And that's obviously only in cases where there is a jurisdictional challenge. It might be possible to agree jurisdiction with the other side, and that can often take place at quite an early stage. So you can hopefully establish that and remove that risk, I suppose. And that's for both parties. Often even for the company or the individual defending the claim, they will want to have that certainty of where the jurisdiction is, and so that they can understand and they can work from there.
And actually, I think we see that more and more. In the first couple of years after Brexit, there was a lot of uncertainty about jurisdiction. And in my opinion, in the more recent year or so, we have seen more defendants accepting jurisdiction of England and Wales, which makes claims easier to bring because there is less of a risk. And yes, it is in their interest as well, because then everything can move forward, rehabilitation can be put in place, etc.
I was going to ask, why do you think that is the case, that more defendants are willing to kind of accept the jurisdiction a little bit easier? Is that just a practical thing of let's get these cases through a little bit easier, quicker, or is there more to it?
I think there's no general rule. It probably depends on internal policies of insurers or potential defendants. And it's probably also down to now having more case law from the High Court in particular about what would make jurisdiction challenge successful or not from defendants. So now that the situation is slightly more clearer, it's not completely clear, but it's slightly clearer, I think insurers and defendant solicitors as well are probably less keen on bringing these challenges.
That's a bit of a complexity that's hopefully a little bit easier to navigate going forward, especially if there's continuing case law coming through as to what makes a challenge a lot easier or more difficult.
That's the thing with Brexit, is it completely, has changed the process. So there's still developing case law, and it's important that people stay on top of the changes and the recent developments. And that's why, getting a specialist is really important as well, because the law has been changing quite quickly in the space of the last few years in that area.
How so, if you don't mind me asking? What are some of the broad stroke examples?
Well, those jurisdictional issues that Morgan was touching upon. So there's more case law to determine what the factors the court might assess in determining whether England and Wales is the appropriate place to bring the claim. So it might be things such as whether witnesses are based, whether liability is admitted or not, issues around factual evidence, so where evidence can be gathered, where experts might be based, if there's expert evidence required. So all these different factors are things that the court will consider. And that's, important that case law has kind of established those principles. Then we can then, use those when we go to the judge or when we submit a reason for that jurisdiction effectively.
Mark, I'd ask Maud the same question, but for you as well. In regards to an international claim, if I'm bringing a claim as a client or as someone who's needing to refer on to a specialist, what's the first thing? What should I be putting at the top of my list to do?
If you're referring something to us, I think it's always just really good just to have a chat, because there's lots of things that you might not have considered. You might not be aware of these issues. As we say, like limitation periods can really vary. So, trying to establish things early on is really important. If that person is sort of if it's still in that country, then there might be evidence that we can gather, as we've touched upon earlier. But it might also be the case that, simple things that we can sort of hopefully give guidance on, but then have that discussion around, let us have a discussion with you and hopefully with that individual, so that we can best support them going forwards. And obviously we're very happy to do that on a no obligation basis. There's no cost for that. That's just something we have that initial discussion and take it forward from there, hopefully.
Well, I think we'll leave things there for today. Mark and Maud, I'd love to thank you both for joining us today on Legal Thinking. Really appreciate your time and coming and having a chat about all things international claims.
Thank you, Cal. Thank you for having us.
Thanks for watching this episode of RWK Goodman's Legal Thinking podcast. For more information on our firm's injury expertise, please visit rwkgoodman.com/injury. If you're keen to watch more from the firm, please feel free to subscribe here. Or if you want to watch more legal thinking videos, please follow the playlist here. Thanks for watching.